Imagine a president issues an order. One court stops it for everyone in the entire country. Powerful, right? But what if that power is suddenly gone? Get ready. A monumental Supreme Court decision just reshaped the very limits of presidential power. You need to hear about Trump v. CASA, Inc. Today, we're diving deep into the Supreme Court's recent decision in Trump v. CASA, Inc., decided on June 27, 2025. This case isn't just about a specific executive order. It's about the fundamental power of federal courts to issue universal injunctions, orders that stop the government from enforcing a policy against anyone, not just the people who sued. The court granted a partial stay on injunctions issued against President Donald Trump's executive order 14,160, signaling a major shift in how executive actions can be challenged. At the heart of this case was President Trump's Executive Order No. 14,160, titled Protecting the Meaning and Value of American Citizenship. This order sought to define circumstances where a person born in the U.S. might not be recognized as an American citizen. Naturally, this sparked major legal challenges. Individuals, organizations, and even several states filed lawsuits arguing the order was unlawful. Lower federal courts agreed, issuing universal preliminary injunctions that barred the executive branch from applying this policy to anyone in the country. The government appealed, arguing that these sweeping injunctions went too far. Writing for the majority, Justice Amy Coney Barrett delivered a clear message. Universal injunctions likely exceed the equitable authority granted to federal courts by Congress. The core of her argument is rooted in history. Justice Barrett emphasized that federal courts' power to issue remedies is limited to what was traditionally accorded by courts of equity at the nation's founding in 1789. She meticulously explained that neither English courts of chancery nor early American courts issued remedies remotely like a national injunction. Injunctions were typically party-specific, meaning they only applied to the individuals directly involved in the lawsuit. The majority also rejected the argument that universal injunctions are simply a modern form of a bill of peace, a historical legal tool. While bills of peace allowed groups to litigate together, they were for small and cohesive groups and bound all members. Universal injunctions, however, bind only the parties, yet attempt to reach everyone affected by an executive action, effectively bypassing the procedures of a class action lawsuit. Justice Barrett also clarified that complete relief for a plaintiff does not mean universal relief for everyone potentially impacted. Finally, the majority stated that policy arguments, while important, were irrelevant to the legal question of judicial authority. They also highlighted that universal injunctions cause irreparable harm to the government by improperly intruding on the executive branch. But this decision was not unanimous. Justices Sotomayor and Jackson filed strong dissents, raising critical concerns about the majority's ruling. Justice Sotomayor argued that universal injunctions are sometimes essential to provide complete relief, especially for large organizations and states dealing with broad governmental policies. She countered the majority's historical analysis, citing instances where American courts have historically used equitable authority to universally enjoin federal and state laws, pointing to cases like Lewis Publishing Co., v. Morgan, and Pierce v. Society of Sisters. She also emphasized the chaos and administrative burden that a patchwork injunction system would create. Most powerfully, Justice Sotomayor highlighted the severe, irreparable harm to newborns and families if the executive order were enforced, potentially rendering American-born children stateless. Justice Ketanji Brown Jackson's dissent focused on the fundamental principles of the rule of law. She argued that when a court determines executive conduct is unlawful, that determination should apply universally, ensuring the executive branch adheres to the law across the board. Justice Jackson warned that limiting injunctions could lead to an imperial executive, where the government can act whatever it wants, to whomever it wants, unless and until each affected individual affirmatively invokes the law's protection. So, what does this all mean? The Supreme Court's decision in Trump v. CASA, Inc. significantly narrows the ability of federal courts to issue broad, nationwide injunctions against executive actions, while the immediate injunctions against Executive Order 14,160 are now limited to the specific plaintiffs who sued. The broader impact is clear. Challenging executive power through universal injunctions will be much harder. This could lead to a patchwork of legal outcomes, where a policy is blocked in some areas, but enforceable in others. This ruling underscores the ongoing tension between executive authority and judicial checks. It also highlights the importance of traditional legal tools like class actions, though Justice Sotomayor noted they might not be a perfect substitute. What do you think about this decision? Does it protect the separation of powers, or does it risk an imperial executive? Let us know in the comments below. Don't forget to like this video, subscribe for more legal analysis, hit the notification bell so you don't miss our next deep dive.